We're gonna have them come in through that door. State, are you ready?
Hey, ready, Judge.
Defense, are you ready?
Ready, Your Honor.
Mr. Bailey, if you could bring in the panel. Justin Floyd,
Yes, sir.
you're gonna gonna sit on that chair against the wall. Cynthia Walker. Sit in the chair in front. Annette Shepherd, please sit in the next chair. And Reginald Tyler,
Sir.
now sit in the next chair. I have to get another chair. Dwayne Benoit. This first, the first row, all the way to the end. And Miss Hardy, no. Mr. Benoit, go all the way to the end, that chair all the way on the end. Miss Hardy, you're gonna stand that chair. Miss Hardy is the chair right here. That has the black and yellow tape on it. And how you pronounce that?
Alicia
Pazinski, that chair against the wall. Because number 6 isn't here, right?
Right.
And Holly Baden, walk all the way down that row as the chair against the wall. Yeah, right there. You're gonna get them. Trina Grace on the second row. You're gonna walk all the way down to the chair in the middle of the second row. Keep walking. The middle of the second row. And then Mr. Rito, come down that second row, you're gonna get that chair that's on the end right there. And what's that, Casey?
Yes, sir.
LeBaron, that chair that's right in front of you. And then Mr. Picnic, walk down the third row, all the way to the chair that's on the end, near the exit sign. With the black and yellow tape. Randy Kesnick, that third row right there, walk all the way down to the end. And you're gonna sit on that first chair and the second right there. And then Mr. Broussard, the chair with the black and yellow tape. Mr. Solis, the chair that you're standing by. And Ms. Hill, you're gonna walk all the way down the last aisle. You're gonna sit in the chair in that second set of seats with the black and yellow tape. William James. Last row, chair with the black and yellow tape. And Mr. McCown, that chair, and Doris Daniel, chair against the wall. You may be seated.
The first two rows, check your pocket, and then somebody dropped a $5 bill.
Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to County Court at Law number 2 to serve as a juror in a criminal case that we have on our docket. You will be examined for inclusion on a jury hearing criminal cases. Our courtroom hours are normally from 9 a.m. to 5 p.m. However, sometimes we have other matters in this court at 9 in the morning. Therefore, our court hours will start a little later than 9 a.m. And we will let you know at the end of each day when you will return to resume your service as jurors in this case. Now, whether or not you're selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which require a careful and impartial and a correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for lunch, and at night. I have an administrative matter that I must attend before administering the first of 2 oaths you will be asked to take as jurors. Now, first, I need every one of you to raise your right hand. And once I finish administering the first oath, I need everyone to please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service as and qualifications as a juror, so help you God? You may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated as a juror, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, first, I must determine whether or not you're qualified. I will ask questions, and when I ask the question, I just want you to answer it to yourself. And once I finish asking the final question, I will then say, is anyone disqualified under the law? And if you believe that you are disqualified under the law after answering the questions to yourself, just please raise your right hand. And then I would ask that you will come up before the court so that we could discuss the matter privately before the bench. And I will put this device on so that no one can hear the discussion. First question. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question I must ask, we're not trying to pry into your personal affairs, but it's just a question that I'm required by law to ask. And this question states, are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is there anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. We have one. Yes. Let the record reflect that the court is back in session in cause number M330208, case of style, the state of Texas versus Demetrius Gerald Wheeler. Let the record also reflect that Mr. Wheeler is present in court with his attorney, Mr. West. Let the record also reflect that the state is present with Assistant District Attorney Colby Hoffmeyer and Assistant District Attorney Lamar Johnson. Let the record also reflect that the jury panel is present in court. The court has just went over qualifications for the panel to serve as a juror in this case. At this present time, all the panel is qualified to serve as jurors in this case. Now, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, please continue to remain seated. Now, I will ask the questions in the same manner that I asked the questions to determine whether or not you are qualified. And I just need each and every one of you to answer the question to yourself. And then once you finish answering the questions to yourself, and once I finish asking the questions, then I will ask if any of these exemptions apply to you and whether or not you want to claim one of the exemptions. First question, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12? And jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed away from your home station and out of Jefferson County? Now, if any of these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Let the record reflect that no one on the panel have raised their right hand, so no one is claiming an exemption. I will now move on to excuses. If you or any of you feel there is a reason why you cannot serve as a juror, then you may be able to claim an excuse. A juror may be excused for observance of a religious holiday upon the completion of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Now, is there anyone here that is claiming an excuse? Okay. At this time, we're gonna ask juror number 4 to come back up. Is there anyone else present that had a hand up that I didn't see? Okay. So at this time, we're going to proceed with the voir dire. At that point, the attorneys will have an opportunity to talk to each and every one of you. And just for the record, let the record reflect that the court has convened in cause number M330208, case to style the state of Texas versus Demetrius Gerald Wheeler. Let the record reflect that Mr. Wheeler is present, and Mr. Wheeler is present with his attorney, Attorney John West. The state is present with Assistant District Attorneys, Attorney Colby Hoffbauer
Good afternoon.
and Attorney Lamar Johnson. Our court reporter this afternoon is Ms. Ada Christie. Ms. Christie, she will be taking down everything that is being said, so speak up when you are answering or asking questions. Our bailiff here, you've already met him, Mr. Charlie Porter. Our defendant, Mr. Demetrius Gerald Wheeler, is charged by information with the Class A misdemeanor offense of assault. The punishment range for a Class A misdemeanor is a person could be sentenced from 0 days to 365 days, which is a year in the county jail. They could be given a fine from $0 to $4,000, or they can be given both such fine and confinement. Or the person may be eligible for either probation. We have two types of probation. One is regular probation, and the other one is deferred to, well, just in this case, it would be just regular probation. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately with this sound device. Is the state ready to proceed?
Except that I need to switch this over.
Okay.
Again, this,
Yeah, have her come in.
Mr. Garrett,
Yeah.
no problem. Yeah, I got it. Apologize. Hope you think I'm ready to go. Just, you know, wait. I was suggesting. Brief, I understand.
How long it's gonna take?
It shouldn't take long, but 5, 10 minutes, if that's all right. So where I'm really waiting up. I'll be good.
There he is right there.
I'd
Yeah,
suggest we take a break if that's.
Yeah, that's what we're gonna do. Ladies and gentlemen, we're gonna take a 10-minute break. Y'all can just go back out into the hallway. Now, when you come back into the courtroom, you're gonna sit in the same seats that you're currently sitting in. Okay. Just follow the bill.
So, John, that's how you rock and sound.
Wait, on to the judge.
Oh, okay. The court is back in session in clause number clause number M330-208, case is styled the state of Texas versus Demetrius Gerald Wheeler. Let the record reflect that Mr. Wheeler is present in court with his attorney, Attorney John West. State is present with Assistant District Attorney Kobe Hallfire and Assistant District Attorney, Attorney Lamar Johnson. Defense, are you ready?
Ready.
State, are you ready?
State's ready, Judge.
Mr. Hoffmeyer, the panel is now yours. You have 30 minutes, and I will be keeping time.
Thanks, sir. Please, the court, counsel. Good afternoon, ladies and gentlemen. All right, we do better than that, right? Good afternoon. I'm doing okay? All right, we appreciate it. First of all, I want to say for your patience, obviously, and I know about this panel, y'all came yesterday, I'm correct, for the felony court, is that right? Or y'all came straight here? Y'all come straight here, so y'all didn't have to go. I was gonna thank you again if you got released from the felony court, only come over here and our things over there. But thank you for your patience. Anyway, I want to reiterate with the judge that in regards to this, we can't do this without a jury panel. We can't do this without the community. Okay, this is important. Okay, it's essential to our system, and our system is good. It's the best there is. It's not perfect, but it's the best there is, and it only works if y'all participate. Which I thank you. I don't have to tell you because you came, right? Not everybody when they got that slip or got that notification did that, right? So I want to thank you from the outset for that. Okay, that serves the community, and that's what we want everybody to do. So before we go anything, yeah, but the people that get the notice, tell them to come on down. It's not that bad, right? Okay, I'll save your judgment until the end of it, okay? But tell them to come on down. We need their participation too, right? Okay, we need to vote, and we need you to participate in the jury service, right? That's part of it. Okay, now my name is Kobe Hoffmeyer. I'm an assistant criminal district attorney. I've got, and now look, I'm gonna tell you a little about myself because I'm about to ask you questions about yourself, and that's not fair for me to do that without letting you know who I am. Okay, I've been a prosecutor for 17 years plus some of my age. Okay, now I've worked here in Jefferson County for the majority of that. I was born and raised in Wayne, Texas, right in Chambers County. Now I got some questions for excuse me, Ms. Shepherd about that. I'll talk about that in a second. Now, I went to Lamar University and I went to South Texas College of Law in Houston. All I wanted to do was be a prosecutor. Was I interned here while I was in law school. Okay, and that's all I've ever been. Never regretted it one day in my life. I love it. I was always told, find what you love to do, then you never work. I feel like I'm not working right here today at all. Right? So now I worked in Jefferson County, I've worked in Bell County, about Fort Hood. I've also worked in Liberty County and my home county of Chambers. Okay. Now, what we're dealing with, and my co-counsel, Mr. Lamar Johnson, he's also an assistant criminal district attorney. Okay, our job is the state. When the court says the state, that means the district attorney's office. Okay, we act, it is our job to prove in a criminal court each and every element of a criminal charge. Okay, this for misdemeanor beyond a reasonable doubt. Okay, so it's always our job, it never changes, right? Always our job to prove each and every element of a criminal case. Anybody heard that before? There's some shaking heads. That's the state's job in a criminal case. It's not like a civil case where it's more likely than not one or the other, right? And a civil case is about money. I ain't here about money. All right. This is about a crime, right? Now we're dealing with misdemeanors. Okay, misdemeanors are what is the punishment range is up to a $4,000 fine and or a year in jail. Okay, felony court, the two courts next to this one deal with felony crimes. So they're more violent. They're a lot more punishment. Okay, prison terms. Okay, we're talking about jail and we're talking about lesser crimes. However, it's still a crime, right? It's a misdemeanor case and they're subject to a jury trial. if that's what the defendant or what we said, the person who alleged to commit the crime wants, right? And that's their duty to have that. Nothing changes, right? So our job is to prosecute misdemeanor crimes that occur in Jefferson County. Okay, this is the place where it's done, in this courthouse, and these two courts, all right? So I work at the pleasure of Judge Keith Giblin, former judge, federal judge, and now he's a district attorney here in Jefferson County. So we work, me and Mr. Johnson both work at the pleasure of him, okay? Now, we're here on the assault violent injury case. Right from the outset, what do you think about that, Mr. Cloyd? Tell me, on the assault case, what do you automatically think? Fight, maybe somebody hit somebody, right? That come to your head? What about you, Mr. Walker? Same thing?
Someone hit somebody.
Somebody hit somebody, right? Mr. Shepherd, what do you think?
Feature an attack.
An attack, okay? Anybody think of anything different coming there? And those are common things to think about an assault, right? Now, we write bodily injury because that's what's required in a misdemeanor case for an assault. Now, assault, we have different levels in criminal law, okay? We have what we call an offensive touching, a simple assault. That's a class C misdemeanor, okay? That's in a JP court or a city court, all right? Not in this court. This is the next level. This has to do with bodily injury, okay? Bodily injury is a little more. Then we get in the felony courts, aggravated assault. Aggravated assault with a deadly weapon. Those are higher crimes. You understand what I'm saying? But assault's in there. Okay, so we got certain levels. What we're dealing with is assault bodily injury. I'm going to show you the elements I got to prove. Now, first of all, is it illegal in Texas, Ms. Walker, to assault somebody? It is. All right. Why is that? What do you think?
I think because if you hit somebody, you could possibly hurt them.
There you go. All right. Once Walker said somebody, everybody heard, he probably hurt somebody, right? So if you think of other reason why it's illegal, other than what we think is obvious, right? You think of something, Mr. Rideau. You could kill somebody, right? We don't know, right? Now, for example, what Mr. Rideau said, it could hurt somebody, could kill them, right? Well, what if they have you don't know about this, but they have a brain injury, right? That they suffer from, and then you hit somebody like you would hit a normal person, but that killed them, right? That can happen, right? So what's the best way to not have that something like that occur? Don't hit anybody, right? Now, we'll talk about other reasons where like self-defense and those kind of other things, but generally that's where our law stands. Does everybody agree with that? Does it sound like a good law? Is that a good law? Yeah, don't hit. Look, your rights. You ever heard? I don't know if you ever heard. You ever right? My rights stop at your nose. Right? You ever heard that before? Anybody, I can do whatever I want as long as I'm not hurting anybody else or impeding upon their rights. Right? You understand what I'm saying? Okay. Now, bodily injury means a physical pain, illness, any impairment of the condition. That's what the law says, right? In order to prove an assault, I have to prove bodily injury. Now, that's just those are fancy words for pain. All it requires is pain. Now, would that surprise anybody? What about you, Miss Hardy? No, excuse me, Miss Grace. No, that surprise you at all? Okay, it's just pain. Now, did anybody see anywhere about like you must feel pain? Do y'all see anything about like blood, right? Okay, or ever hear that? Like it has to cause blood. It has to cause you to go to the hospital. You need to have stitches, anything like that. It's just pain. Okay. Does it say anything about visible? Okay, now serious injury means like a broken bone. Okay, I'll give you that example. What do you think about that, Mr. Benoit? That would be more, that's aggravated assault. Okay, now will it qualify? No, but pain is the threshold for our purpose. Does everybody hear what I'm saying? So all it has to cause is pain. Now, that can come from injury. Like I said, it comes from what the victim testifies to, whether or not they're caused the pain. All right. Some people think that that's too small. Is there anybody out there who thinks, I think I need a little more? They probably need to bleed. They probably need to go to the hospital. You think that, Mr. Hart?
Yes,
You think that it needs to be more than just pain? You do? Okay, thank you, ma'am. Did anybody agree with Ms. Hart? That it probably, okay, Mr. Floyd, juror number one, and Ms. Hart, that you think it needs to be more than just pain, right? You understand though, like that the law says it's your thing, right? And it's okay, and I'm glad you said that because it's important for y'all to know, look, you don't have to agree with all the laws. That's not, you understand what they are, it doesn't mean you have to personally agree with them. But I give this example, and it doesn't even apply anymore because they kind of changed the laws. In West Texas, anybody ever been on West Texas? All right, you drive from San Antonio to El Paso, driving like in 3 countries, all right, but that's in our state. However, they used to have a 65-mile-an-hour speed limit. Now, you wouldn't see a person for 4 hours, not much less. You see what I'm saying? So I didn't ever understand why there's a speed limit if there's nobody out there when you're driving. Right? Now they've changed it where, you know, you don't have in certain counties. But that didn't make sense to me, right? I didn't agree with that law for those counties with the people. Right? Now, I know the reason, obviously, but it didn't make sense. Okay, it's okay to disagree with the law. Just understand that that's what it is, right? And we're asking for y'all's opinion. I thank you, Ms. Hart, for doing that. It's important in these kind of cases. Right? Everybody with me? Anybody lost? I talk fast, I talk with my hands and I move around. Sorry, I wish if you could tie my hands on my back, you would hear a word from. Okay, I can't do nothing about it. I come by honestly, okay? So now, we've already talked about that. We're also a civilized society, right? This is no longer we're walking around with clubs and hitting people, right? Whether we want something, we're gonna take it. No, we don't live like that, right? We live in a society with laws that everybody has to follow, right? Everybody who's above the law, nobody. Right? So we have a civilized society, we don't assault people. Now, it's dangerous. We talked about that with Mr. Rideau. Now, hurt someone, bodily injury, make sure we went through that. Now, what are examples of evidence that may show that somebody suffered a bodily injury? Miss. Wow.
Cuts, bleeding.
Okay, so that would, you say, if that was say, a picture, right? That would show somebody caused pain, right? If they got a cut, usually.
Yeah.
Okay, now what about you, Miss, excuse me, LeBure? Is that right?
Yes, sir.
Yeah, two, all right.
The same, yes, sir.
Okay, something like, some bleeding.
Yes.
Like, what about, I mean, it's hardly like a trip to the hospital, medical record, showing that, you know, contusion. Is a contusion is just a fancy word for wound, right? Okay. I got anybody that works in healthcare that, I think I saw somebody work in healthcare. Yeah, yes, ma'am, Miss James, or excuse me, Miss Hill, Miss Hill. So contusion, right? Bruise. Okay, that could show pain, right? Now, what about somebody just saying, look, it hurt, it caused me pain, right? Even though there's not visible injuries. Right? Does anybody have a problem? I know we talked about, we've already talked about that. Anybody else think that? Like, just not, nothing says it's hurt, it needs more, right? Well, what would you like to see as evidence in a trial of assault injury? Okay, to prove that someone has been assaulted. What do you think, Miss, excuse me? Mr. Dole? Hey, excuse me.
X-ray or some
X-ray.
pictures, photos of the injury?
Okay, photograph. And what about video? Like a video of the person? That could show it, similar to a photograph, right, Ms. Greenwell? Is that,
Right.
that's similar to it, it's at around the time. Okay, now what, now, Miss Grace, what if, do you know of an injury? Oh, excuse me, Mr. Park. You okay?
Yes.
Now, Ms. Grace, what if somebody you've proven that they were assaulted, but the injury wasn't visible immediately. Can you think of a situation where that would come about? Meaning some people bruise quickly, right? Some people, or some injuries don't bruise automatic or don't bruise within, within an hour, right? But you wake up, like sometimes with a black eye. Okay, give an example of that. You wake up and it looks 10 times worse than it did when you got hit, right? Now, is that normal? Sometimes, and sometimes it might be not. Give you an example of it not. It's normal, but when the blood comes, it becomes worse, right? What about Mr. And we talked to Mr. Rideau, Mr. Pitney, what would you think? What about injury where somebody was grabbed around their neck? So, a lot of people don't do it. Okay, a lot of people don't. If anybody disagree with Mr. Pickney about a lot of people not bruising, What, would you agree with Mr. Pigney that everybody's different, right? Yeah, so there's no for sure way that we can say, well, if this happened, this is gonna show. Is there a way to do that with everybody? Or every person's different? Everybody's different, right? Anybody disagree with Mr. Pigney? Okay, now, we talked about video, we talked about photos. What about testimony? That's evidence, right? Somebody comes in and tells you what, right? So if we had someone in particular in an assault case, they came in and they didn't have visible injuries, but they said, yes, that caused me pain. It hurt. Some people might think that's not enough, right? I need more than that, right? Is there anybody who thinks that? We've talked about Ms. Harding and Mr. Floyd, but like thinks, no, it's not enough just a testimony of that. Right? What about you, ma'am, Ms. Kismet? It's never happened. It's never happened.
Yeah.
What do you think?
Depends on if they're credible or not.
Okay, and credibility comes from, what do you think?
Their body language, their tone, compare themselves, their consistent story.
Now, who do you think decides that, Ms. Kismet, in a jury trial? Who decides whether a witness is credible?
The jury.
You do. Who's ever on the jury panel, right? All of that comes into play. Okay, so it's not just enough to say it has to be whether or not it's credible, right? I'm glad you said that. Who determines that? The jury. You're the judges in the case. The judge is Judge Holmes, right? But when it comes to a jury trial, you decide what happened. You decide the facts. You decide, most importantly, whether or not the state, me, never changes. Me, it's my responsibility to prove each and every element of the case beyond reasonable doubt. Now, what happens if I don't prove one of those elements beyond reasonable doubt? You know.
You have to consider it all.
Okay, what's the result if I absolutely did not prove it was definitely counted?
We would have to.
Acquitted.
Yeah.
Not guilty, goes home, period. End of sentence, that's how it works. All right, so responsibility never changes. It's my responsibility as a state to prove each of those elements. And your job is to make sure that's done, and if it's not, you send them home. Done, period. Okay. Defendant has no obligation in a criminal case. Okay. Now, probably raise your hand, watch CSI, NCIS, whatever law and order, I don't know anybody who watches all that. All right, what about investigative discovery and all these, catch a murderer and everything else? All the other hands go up. I do too, all right? Awesome, okay? Now, is that reality? I wish it was, all right? Okay, I watch them all shoot. Now, understand, now the best thing when you explain is television versus reality. I wish it was exciting. It's just not, all right? No criminal case in the history of our justice system is somebody done a crime, been arrested, put in prison, and all within 45 minutes. Never, okay? Ever. And good looking people everywhere. All right? Just don't happen. All right, so y'all understand that now, I heard a joke a long time from Judge Gist, who's no longer with us anymore, but I thought it was the funniest thing I'd ever heard about this kind of stuff. He said, I watched one of those shows the other day and they found fingerprints on sand at the beach. Now, think about that for a second. All right, now, that will never happen, okay? But I told Judge Gist at the time, can I use that? Because that's the best example I can have for, look, television is television, reality is reality, right? Now, I'm gonna ask I'm gonna go through this really quickly with y'all, okay? I'm gonna let you read the sentence, all right? And I'm gonna give you 6 possible answers, okay? We do this because it's not possible for us to talk to you individually enough, so we have to get something to talk to you about, okay? So what I'm gonna do is, I'm gonna read you the sentence, the question, and then I'm gonna give you 6 possible answers. I'm gonna go down the line and just have you give me the number. You don't have to say the word, okay? You just give me the number of where you would fall on this scale, okay? So if supported by the evidence, how comfortable would you feel finding someone guilty of assault without visible injuries on the complaining witness? Everybody get that question? Okay, now what the results, I'm gonna trip over counsel's sentence board there. There it is again. Now, so What I've got, number one is very uncomfortable. Okay, number two, uncomfortable. And so on. Three, somewhat uncomfortable. Four, somewhat comfortable. Five, comfortable. And six, very comfortable. Now, everybody understand that. It's just a scale of, I'm not about, no, very uncomfortable. I would say, and I'm not put words in your mouth, sorry, but I'll say you'd be in number one, right? Very uncomfortable, okay? Mr. Floyd, probably that, right? Okay, now, so the other end of that is very comfortable, meaning that's fine, right? But whatever you give, all I'm gonna go, everybody got the question. Understand what it is before we start. I'm gonna go down the line and just ask you for the number. You don't have to tell me the word, nothing. What number represents how you feel about it? Everybody ready? Ready? Come on, we gotta get up, we gotta get ready. Y'all ready? Okay. Juror number one. Okay, juror number two. Juror number three.
Four.
Juror number, excuse me, juror number five. Juror number seven is hard.
One.
Okay, thank you, ma'am. Juror number eight. Okay, juror number nine. Okay, juror number 10 was great. Okay, juror number 11 was Rebecca. Juror number 12 is the viewer. Okay, juror number, Mr. Pickney, juror number 13. Okay, let's skip, sorry. Let's skip. I go through this, skip juror, I'm sorry. Mr. 4, juror number 9, went on. Mr. Pickney, juror number 17, 13. All these numbers flying around, slow down, all right. Juror number 13. All right, thank you, sir. And juror number 14. Okay, juror number 15. Thank you, sir. Juror number 16. Is it Solus or Soli? Thank you, Mr. Lee. Juror number 17 is it. Juror number 18, Mr. James. Okay. And juror number 19, Mr. McCown. And juror number 20, Daniel. Thank you, man. Thank y'all very much. Okay. Now, burdens of proof. I've already gone over this. What I want to make sure you understand is this is the highest burden of proof in a criminal court. All right, beyond a reasonable doubt. That means I got to prove each and one of those elements. It's the highest burden. Civil case, and I know it's hard to read because you don't have a good view of it. Civil case is by preponderance of the evidence. All right, that means it's just a little more on one side. More likely than not, you win. Okay, that's enough proof. Right now, CBS cases in which it's an abusive home. Okay, where a child is taken out of an abusive home. That's by preponderance of the achievement, by clear and convincing evidence. That's a little bit more. Okay, but the highest one is the one y'all are hearing what I have to prove beyond a reasonable doubt. Everybody got that? Okay, I'm gonna give you an example of we talk about this. Now, Texas law prevents us from giving you a definition. They used to do it way before my time. They used to be able to give beyond a reasonable doubt a definition by law. Okay. So I can't give that to you now, all right? But I can tell you what it's not, all right? I can tell you that it's not beyond all doubt. Okay. Beyond all doubt would be what? Now, good example, let me say, Mr. Broussard. But if it was beyond all doubt, what would you think it would require? You'd have been there, right? Like if you, I saw it with my eyes, I watched it. Now, if you be on a jury, if you watch what happened, where would you be? Not in that big box. In that little box over there with the mic. You testify, right? So you can't be that, right? So it's not that, right? And before I move on, ladies and gentlemen, they're sitting in the box and let you know they're students at Lamar and they're watching through and they work with our spinal top, okay? MHMR and their social worker and also criminal justice major. So they're watching this as part of their class. So I wanted to let you know who they were. Okay. Now they're sitting in the jury box where the panel will be sitting in the trial. Okay. Now, it's not beyond a shadow of a doubt. Y'all ever heard that? That's TV. That's Matlock, right? Emergency room. That's not a real term, okay? That's for television. That's never been used in our law. Okay. Now, best way to explain it is you'll know it when you see it. Okay. It's a personal thing about whether or not you have, whether or not it's been proven beyond a reasonable doubt. Okay. Like I said, it's not beyond all doubt, but you know when you see it. Okay. Now, All you need is what? Common sense. Did they require you when they checked you for, the metal detectors out there to check your common sense on a box and you come back and pick it up on the way out? Did they? No, right? Y'all all got common sense. There's nothing requires you sit on a jury other than your common sense. Every one of you have, okay? And that's important because, you know why? Because the community sets the terms on whether or not what we will abide and what we will not abide. Okay? That's why it's important. That's why our system is important. The community sets the terms. And that's you. That's me. That's everybody here, right? So do you have to go to class to be a juror? No. You just have to be a citizen, have your common sense. You have it, you're ready. That's all you need. Now, it's not beyond, it's common sense. It's an all criminal trial in the United States. Y'all see them on TV, right? Y'all saw the thing in South Carolina or North South Carolina just happened where everybody went about the lawyer and the family and all that. Okay, all of that. It's not impossible to meet. It's done every day, all over the country. Okay. Now, it applies only to the elements of the crime. All right. The elements are on a specific date.
So how far you have 5 minutes?
Thank you, Judge. Now, everybody see what's on this, Mr. Shepherd? You see what's on this? Okay, what is that?
It's a pistol.
Is it a
A
pistol? A
A
puzzle?
of a
Picture,
pistol.
all right. Okay, now are all the, you see it's a puzzle, but it's got missing pieces, right? Now, do the fact that it's missing pieces keep you from telling what it is? Same thing as a trial, okay? Evidence provides the pieces of the puzzle. Now, you may not see every piece, but it doesn't keep you from making whether or not it's proven beyond a reasonable doubt, right? Does everybody understand what we're saying? Okay, now, all you need is common sense once again. Now, does anybody know or know anybody in the family of Mr. Demetrius Wheeler? It's important that we ask that. Does anybody know? Everybody silence. I see nobody. Okay. What about Mr. John West? His defense attorney, his attorney, excuse me. Anybody know Mr. West? All right, Mr. Kuczynski, excuse me. Keeston. Yeah.
Know him, but we've had interactions.
Okay, you've had interactions through work or,
My former employer.
okay. Now, something about that relationship, okay, would it impede you or allow you to say what the law calls a bias of prejudice, where you couldn't be fair to the state because you knew Mr. West? You could be fair and impartial and listen to all the facts. Okay. All right. Thank you, ma'am. Anybody else? Thank you for speaking up. I appreciate it. Now, I want to reiterate what Judge said. Anytime, any of the questions, like a few questions I have left, or Mr. West, anything you're uncomfortable about answering, we'll go up there and we speak with the white lawyer. It's done all the time. It's not a big deal anyway. So if you have an issue with any questions I asked, a little short time that I have, or Mr. West, it's no big deal to say, I'd rather do that over the bed. Okay, we do that all the time. Right. Now, we talked about prior criminal jury service and what we have your jury questionnaires. It looks like, Mr. Rodeau, you served on a criminal jury, is that right? What kind of case was that, if you don't mind that? Okay. Was it here in Jefferson County? Okay, was it, did you assess any punishment or did the court assess any punishment? Okay, but it was, that's how it was all. I thank you. Now, anything about that case that would limit you and that you could not be fair and impartial on this particular case? Now, anybody else? There was, I believe, one other person, Ms. Solis, you served on a criminal jury before? Okay, now, was that here in Jefferson County? It was. Okay, and did y'all assess any punishment or was it the court? Okay, all right, but it came to a verdict and then it was punished. Is that right? Thank you, sir. Now, anything about that would limit you from getting over to testify. I mean, excuse me, not testify, but this is the evidence here. Okay. Now, nobody else, is that right? Okay, now quickly. It's important. Anyone who cannot sit in judgment on another person in the context of a criminal trial, or excuse me. And now this is important, and I'm gonna tell you why it's important, because I ask this on every jury I have. All right. I, not probably, it was 8 years ago, I had a sexual assault of a child case in this courthouse in the 252nd District Court. I went through a week of trial, okay, with child testifying, with a serious crime. All a week full of trial to make the determination, a very serious case, we're looking at 25 years to life, okay? During the deliberation, okay, and I asked this question then, but nobody answered it. But I had a juror come back and said, I can't, my religious beliefs prohibit me from making a judgment or to judge another person. Okay, well, that was a mistrial automatically. Now, you see why it's important that I have to ask that, right? As the jury, that's what your job is. Now, it's not judging in that particular case. Now, if it is your religion, that's fine, but we have to know that. I can't find out on Friday of a week trial, because then it's got to all be done over again. You understand? And that was a case where we have to do it with the child, and we got to put the child in there. Okay. So it's important, and I ask it even on these cases. I ask it on this. If it's fine to do that, but we got to let us know. All right, you can't let us know later on. We'll look at. I can't make a decision because I can't do it. You got to know now. Anybody have a problem? Good. It's okay if you do. Right. Now. Oh, let's go. Yes, sir. Sorry. Okay. Would you tell us if you don't mind, if you won't like approach, we can do that, or you can.
I'm okay. I just don't want to be morally responsible for what happens to someone else.
Okay. And understood, right? Now, you understand, Mr. Floyd, that moral responsibility, what we're here is, we're just deciding whether or not the person is committed the acts of a crime. That's all the judgment, not in the morality. You understand? And I understand, I appreciate you speaking up on that. But you understand, as part of a jury, it's your job. You'll be shown something and you have to decide whether or not state's proven this case beyond a reasonable doubt or not. That will be, you become the judge, right? Everybody understand what I'm saying? Okay, do you understand that?
Yeah.
So do you think that you could, knowing that, could you be a fair and impartial juror, sit and make a decision on the facts that are presented, whether or not the state's proven their case?
I do not think so.
Okay, I appreciate that. Thank you. All right, Joe. Now, quickly, juror's duty, okay? You decide the facts. You decide what you get, okay? You decide whether or not the state proving this case through evidence and through testimony. You apply the facts to the law that's going to give it to you from the court in the court's charge, okay? You apply what you heard and the evidence you saw to the fact, to the law the court's going to give you. And then you follow the law, okay? You don't have to have a degree in law. You don't have to have anything but your common sense. And what you brought here today didn't check at the door, right? Okay, now, I asked y'all if they knew Mr. West, like Ms. Shepherd. Ms. Shepherd, you know, I'm asking Ms. Shepherd this because she teaches, right,
Yes, sir.
at East Chambers High School, which is when he stole where I'm from. All right, now, I don't know particularly Ms. Shepherd, but she may know me or my family. Do you know anybody? A Huff Fires program. There are plenty, right?
Yes.
The video students.
Yes.
Okay, is there anything about that? We don't know each other personally.
Yes.
Okay, but anything about you working in East Chambers ISD? And the fact that I'm from there would make it where you couldn't be fair and impartial on the case. Okay, thank you so much for showing up. Now, I want to thank y'all again for all your patience, and I want to thank you for all your answers. It's not easy to get up and stand and talk about this. So I'm going to pass this on to Mr. West. Thank you very much, and look forward to presenting the case to people on the panel. Thank you.
Okay, Mr. West, Mr. Hartbauer went over 3 minutes, so you have 33 minutes.
Probably won't need that, but thank you. May I please report, Council?
Yes.
Morning, everyone. Actually, good afternoon. I'm sorry, it's not morning anymore. I'm just gonna like Mr. Hoffpower did a moment ago, introduce myself. My name is John West, like the judge said. I'm from Southeast Texas as well. I've been practicing about 23 years now. When I first began my career, I was at the district attorney's office. Actually, our intern, I was there. So he actually worked with me a little bit there. And also you're gonna see something I usually jump ahead and do this at the end of the word. Front word out this time on this one. Again, it's not like cheating. These attorneys that work in these courts aren't enemies. We're actually close friends. We're good friends. So you may see us talking together when you walk in the courtroom, maybe chatting or whatever. This is the way it goes. We talk to each other all the time. We're friends outside the office. We've known each other for a very long time. But anyway, what we're here to do today is avoid hour, okay? A lot of people call it jury selection, but it's not really jury selection, it's jury deselection. What happens, we talk to you all, find out things about you, and then we both get to strike people off the list. And the first 6 that are left make the jury count. Okay, so that's how we select the jury. We don't go back and go, I want this one, I want that. It's not like a schoolyard pick where we go back and forth. Okay, we just eliminate people. And then the judge goes, all right, the first 6 that are left, they're the jury. Okay. So that's why we're asking you a bunch of questions. That's why we're getting in your business, so to say, and finding out things about you. We gotta find out if you're good for this jury. Who here believes they're a reasonable person? Raise your hand. Everybody, okay. I hope everybody raised their hand. But there are certain types of cases that might not be good for certain kind of people. Okay, and I use this example, it's kind of an off the wall crazy example, but I like to use off the wall crazy examples to make my point. Does everybody remember President Bush, the older President Bush? He's already passed away, but yes, okay. There was a particular food that he didn't like. Yell it out loud if you know what it is. Somebody?
Broccoli.
No, okay, thank you. I was gonna be afraid that might be the first jury that doesn't have the answer, which would ruin my description here. He didn't like broccoli. He came out and said he didn't like broccoli. I know this is a long time ago. When he was president, and a lot of the farmers got upset. You can't say that. Don't say that. It's bad for us. And he's like, I still like broccoli. Who here doesn't like broccoli? Raise your hand. Yeah. And some people don't like it. My child hates it. I like it personally. Okay. So let's say today's trial is not about a criminal case, but about what the state vegetable text should be broccoli and potatoes. Okay. And let's say he is in one of these seats here, the seat over here, it's empty. Let's say, of course, we have to assume he's still alive, but nevertheless, he's there. Who here thinks he'd be a good juror for that case? Raise your hand if you think he'd be a good juror. Who here believes he's qualified to be a juror? Yeah, of course. Yeah, I mean, the man was president of our country, the leader of the free world, whether you agree with his politics or don't agree with his politics, he's a very well-known person, right? Okay. But he doesn't like broccoli. He's already made that opinion. He has a bias, a prejudice. We use those words, those are negative words, but we all have bias, we all have prejudice, okay? Against certain things, like food, like my daughter has bias or prejudice against broccoli. Okay? President Bush. That's why we're asking questions to find things about you that might make you like, I'm not gonna do this. I remember I tried a case one time years ago, and it was about a burglary of a building. And literally the weekend before I tried the case on Monday, my office got burglarized. So I'm like thinking I'm on a juror because I would not be good for this jury. So that's what we ask you questions. All right, so let's talk about some things. Who here has heard the phrase innocent until proven guilty? Okay. Now, who here believes that's true? Okay. All right. We'll pick on people here and we translate. We'll start at the very beginning. Mr. Cloyd?
Yes, sir.
Innocent until proven guilty. What does that mean?
You can't just have someone point fingers and knock them up.
Okay. Until they proven guilty, right? Okay. Is that the correct word, until? Or is it unless? Anybody? Is there a difference between those two words? Miss Shepherd,
Yes,
there's a big difference, isn't there?
tremendous.
Yes. The correct phrase is innocent unless proven guilty, okay? And the example, one of the other churches we work in front of always says is like, we're gonna work until 5 or we're gonna work unless 5. Those aren't the same thing, are they? Okay? Until means it's going to happen. We all know something crazy happens at 5 o'clock's gonna come on that clock, okay? Unless means it may come, it may not, okay? So that's the burden that the state or the phrase we need to use, innocent unless proven guilty, okay? All right, so let's talk about that, whether the words or whatever. I'm gonna go back to Mr. Floyd. What does that mean now? You were getting, even though that word was wrong, but you were getting the right thing, that people are innocent unless they're proven not to be innocent, right?
Yes, sir, that, you can't keep trying over and over and over.
Right, okay. Ms. Walker? What is innocent unless proven guilty kind of thing?
To me, it means until you tell me something different.
Okay.
He's innocent until you prove to me.
Unless you prove something. Right, okay. All right, talking to Ms. Shepherd, I'm gonna skip you, come over here to Mr. Benoit.
Yes, sir.
What does that kind of mean? Innocent unless proven guilty.
Well, y'all have, it has to be proven that they're guilty
Right. So everybody in our nation is considered innocent, unless the government can prove otherwise. Okay, something put in place for our forefathers, that is because in the pre-United States days, when we were part of the colonies, if the king said you were guilty, you're guilty. Okay, and then our forefathers wanted to make sure we had a system in place that people just couldn't be accused, and then you had to prove yourself not guilty. Okay, all right. So let's do this. Knowing that phrase and knowing that system in place, let's say we had a vote right now. Okay. Well, before I do that, let me ask another question. Ms. Hardy, what evidence have you heard today? None. Exactly. And no evidence. It's just been two attorneys just talking, right? Which is not evidence, by the way. Okay. Well, let's say you had a vote right now. Okay. I'm going to give you three choices: guilty, not guilty, I don't know. Okay. Who here would vote my client's guilty right now if you had a vote? Raise your hand. Actually, surprisingly, I raised it correct, but I had a client or a juror one time raised her hand on this, and I was like, "What are you trying to do?" She goes, "I don't want to be on this jury now." I'm like, "That's a good way to get off the jury." Okay. Next vote is who here would vote not guilty if you had a vote right now? Raise your hand. Okay, we got a few. Okay. Who here would vote? I don't know yet. Okay. That's kind of a trick question. The correct answer is the second one. It's not guilty because, like I said, innocent unless proven guilty. There's been no evidence. They haven't proven, so it has to be not guilty. Okay. There is no I don't know. Okay. What I'm getting at is it stays not guilty unless they prove guilty. That's the only two things you know. Okay. And if you have to vote right now with no evidence, it's not guilty. Right? All right. Now let's talk about the burden. Like Mr. Hopkins said, it's his burden to prove this case beyond a reasonable doubt. And he showed you a couple of different burdens on the screen. I'm gonna go back and illustrate those burdens. Okay, some things you're gonna know, some things you might not know. Okay, who here has heard of the burden of reasonable suspicion? Not really common. Okay, that's when an officer needs to detain someone for questioning. It's more than a hunch or a guess. Okay, now I like to use, like I say, crazy examples. I'm gonna use another crazy example. Let's say at lunchtime today, the bank here got robbed. There's a bank right across the street in Dagenham, Carolina. So you probably don't know that there's a bank only used for employees. Let's say they got robbed at lunch, and they got a description of the person leaving the bank with the money. He was about 6'2", wearing a dark gray suit, white shirt, green tie, had a beard, had glasses. Okay, and I walked in here after they heard that. And this officer over here, Officer Porter, heard that over the radio, and he goes, "Wait a minute, John, come over here, talk to me." Okay, does he have reasonable suspicion to talk to me? Yeah, it's more than 100 guess. I matched the description. Okay, does it mean I did it? No, but he has enough to just talk to me and go, "Hey man, where are you going to lunch?" "Oh, I had lunch with my wife." "Where'd you go?" "Wherever." "All right, okay." Let's go to the next one. It's going to be part of the same scenario here. Who's heard of the burden called probable cause? Yeah, it's much more common. You watch TV, you hear that. That's what an officer needs to arrest or to search. Okay. Let's say during our conversation, we're talking, and my bag, which is right down here, okay, some of you can see it, some of you can't, and he's talking to me, and he looks down, and there's a bunch of like cash and stuff sticking out there. Now, has he met that burden of probable cause to search my bag? You go, "Wait a minute, what's in that bag?" Raise your hand if you think he has probable cause. Yeah, absolutely. Again, does it mean that I did it? No, because we're still down the list here. But it gives him probable cause to search the bag. I could have met a client at lunch who could have paid me, a fee or something. They could have robbed that thing. I don't know, but it's enough for him to make a probable cause. Okay. All right, so let's get away from me being a bank robber for a second. There's another one. Preponderance of the evidence. Who here served on a civil jury before? Raise your hand if you served on a civil jury. We got a couple. All right. Ms. Kitchick, what's the burden in that?
51%.
51%, exactly. That's what's called preponderance of the evidence. It just basically means more than. Well, actually, tell you, I think it's going to be 50.0000000 as far as you want to one. Just anything more than 50%. Okay, it's give the example of you're on a football field, has to just pass the 50-yard line. Whatever it is, it's more likely than not. Okay, it's basically it's the way to put it. It's probably that's probably happened. Okay, whereas reasonable suspicion means might be, might have. Probable cause is maybe. Got some money here. But once the evidence is probable. Okay, this is what people need to take your money from you. your property from you, things like that. And I say money from you, sometimes it's car wrecks, usually your insurance money, but bills, your money, so to say. The next level up is clear and convincing evidence. Has anyone heard that phrase before? Raise your hand. Okay. Who here, I'm gonna ask you to raise your hand. I'm gonna keep your hand up. Okay, who here has children? Or your hand has children? Okay. Who here believes that your children or your child is the most important thing in your life? Keep your hand up, not put it down. Okay, you put your hand down. That's fine. Clear and convincing was the state needs to take your child away. Okay, that's how much evidence they have to have that you're an unfit parent. Okay, basically to take away from the parents here the most important thing in your life. That's what they need. That's how much evidence they need. Clear and convincing. Has to be clear, has to be convincing, has to be more than might be, has to be more than maybe, has to be more than probable. Has to be enough that they're like, yeah, you don't deserve your kid anymore. Okay? Why do I tell you those different levels of burdens? To illustrate to you what beyond a reasonable doubt is. Mr. Hoffmeyer made a comment a moment ago that there used to be a definition before his time. Unfortunately, I'm a little older than him, and it wasn't during my time. We used to have a definition that we read to jurors, or the judge did in the charge. They did away with it towards the end of my time at the DA's office, right before he joined on. Now it's like he said, you're gonna know it when you know it, okay? That's why I'm gonna be these different levels, so you know how high you have to hold them. It can't be like, he did what they said he did. He may have done it. Or even if like, they're convincing, I'm clearly convinced he did it. But it's still not beyond reasonable doubt. Okay, if there's any doubt, any reasonable doubt, any like, that's reasonable doubt. You have just a hesitation, okay? That's why it's really important in a case like this, because you're gonna hear from different witnesses and you have to decide how this goes. How much do I believe this? Oh, he probably did it, it's not enough. He maybe did it, not enough. It has to be on a reasonable doubt. Okay, we talked about, anybody knows Mr. Wheeler, knows knows me. And just for the record, Mr. Ms. Kitchenick, you know me through my work in the courts, right? Because you used to work where? Probation department, okay. So we had a lot of dealings with motions to revoke and things like that, where you were a witness and I asked you questions, right? Right. Okay, all right. But again, we don't even know each other outside of the work duty. Okay. I don't think I've ever seen you outside of this courthouse. All right, well, here's some of the witnesses for the state. Ashanti Moore. They recognize that name. Okay. Tamara Casimore or Casemore. I'm not sure exactly how to say that name. Anybody? Cassandra Long. Okay. All right, we have some officers, and you might know some of these. Jefferson County Sheriff's Officer Matt Gardner. Okay, I'm sure you probably know all of these names. Okay, I understand that. Deputy Scott Weaver, Deputy Chad Williamson, and Deputy John Colander. I'm sure nobody was, good place with any of these or something like that. Let's talk about another phrase we hear a lot in our judicial system: right to remain silent. Have anyone ever heard that phrase before? You watch any kind of TV, you hear that. You've even heard Miranda rights when they arrest people on TV. You have a right to remain silent. You know, they say at the very start. Let's talk to Mr. Rito. Okay, sorry about that. What does right to remain silent mean? Why? Okay, but why is your right? It's something we already talked about. So it's play it out.
And then you say, can you use against you?
Exactly, because why? You're innocent unless proven guilty. That plays together. So a defendant has no obligation to say anything because they have all the burden to prove the case. Okay. Now, in a lot of cases, defendants do take a stand, and I'm not sure, 100% sure if Mr. Wheeler is going to take a stand or not, but probably. But if he doesn't take a stand, Mr. Rito, would you hold that against him? Okay, what do you mean by that? Good answer.
I mean, you're not out to take a stand because it improves some stuff. Why would you take a stand? I mean, it's like me, the church is white. I mean, if you can't see this white, I'm not gonna be.
You're not going to say it, right? Well, why wouldn't somebody take a stand? What are some reasons why somebody would take a stand and testify? Okay. There's no reason to get there say anything more, right? Because he's innocent, let's prove guilty, right? Ms. LeBeau, is it LeBeau? How do you say that?
Look here.
LeBeau, okay.
I get it so anyway.
I apologize, but Mr. Hoffmeyer was so good on all his names, I'm not not as good, not doing as well. What about you? Do you have to hear from the defendant, you think?
No, sir.
Why not?
I got, like you said, if the shirt's white, it's white, you know, like. if
Right.
You, witness and say that it's, you know,
And if you believe the witnesses or don't believe the witnesses, you don't need any extra.
yes, sir. Yes, sir.
And the same question I was asked a moment ago, why would somebody testify? What was some reasons why people might not testify?
If they didn't see it or,
No, I'm talking about the defendant.
oh, defendant, not sure.
Does anybody have any just want to throw out there?
Those are guilty.
That's a good one. That's one of them. Because you testifying will give you into other things that could hurt you. Any other reason why somebody might not testify that's beyond that? Who here is afraid of public speaking? Raise your hand. I'm gonna call you out. No, I'm not gonna ask you about but you're gonna be sitting in front of people having a talk, okay? And some people get nervous in front of others when they speak. Me and Mr. Hoffmeyer don't get nervous in front of anybody speaking. This is what we do. We've been doing this for over 2 decades, both of us. Some people get nervous in front of others. They can't say what they want to say. They get tongue tied. They get easily twisted up, right? And we don't know why somebody doesn't testify. We don't have to say that. They just have the right not to testify. Who here is going to hold that against my client if you don't hear them? I said, I don't know if he's going to testify or not. We're not at that point yet. Like Mr. Rito said, depends on how the case is going, okay? But if you don't hear from him, who's going to hold it against him and go, look, I want to hear what his side is. Raise your hand. Okay? Let's be honest. Everybody wanted to raise your hand, right? Okay, you want to know his side, right? But you don't hold it against him. That's what I'm getting at. Okay, there's a difference there. We all want to hear both sides. But question is, we hold it against him. All right, and the only good thing about me going second in these cases, Hoffmeyer asked most of the questions already. Okay, he has the hard job. He has to ask most of the questions, and I write the notes and go, all right, you already asked those questions. But I got a couple follow-ups I want to add. Because like you said, we get your information sheet, so we know some things about you already. But Mr. Benoit,
Yes.
okay, you have the job that I'm looking forward to having one day. What's your job right now?
Retired.
Retired, exactly. Marty, look, sad. Well, what did you do before you retired? Kind of what
I worked at Huntsman, chemical, basic chemical.
Okay, refinery work? Gotcha, okay. Just want to make sure you are like a probation officer, back there, or a deputy or something like that, okay? I think that was the only one right on that. Oh, no, we have, Mr. Pickney. What do you do right now?
Nothing.
Nothing, okay? What'd you do before you did nothing?
Before I became 100% disabled, I worked at GCR Tires.
Okay. Again, what, one officer, a police officer, anything like that? Okay. I think that's all of those. A lot of times I get a bunch of those and I don't do that. All right, just have 2 more questions really here. Next one, you've been asked this a couple of times, ran in different ways, but does anyone have a reason here today that think you could not be a good juror? You have a broccoli, so to say, something about you that says, look, let me talk. I haven't asked the right question, but you want to say something. This is your chance right now. Anyone? The last thing I'm going to do is do an apology. We're going to apologize for my actions and for my council over here actions, because there's going to be times we're going to see you out in the hallway and we're going to walk away from you. For the 6 you get to jury. You may get on an elevator, you may step back and wait for you to go by yourself or a group of you guys. We might walk into a restaurant, you may be sitting on one side of the restaurant, we may purposely wait to get on the other side of the restaurant or just leave, okay? We're going to appear rude in a sense because we're trying to ignore you outside the courtroom. It's not that way. We're not those kind of people. We would love to talk to you. That's why we did what we did, okay? We just don't want to give anyone a chance to think that something inappropriate is going on, okay? I know Mr. Hoffmeyer, he knows me, we know that we wouldn't do anything like that. We want other people to see and go, look, John got in the elevator with that juror. What are they talking about? They're talking about the case. a chance to say it. He doesn't want to be another chance to say that. So that being said, this is our last chance to talk about this. After 6 of you get picked, we're gonna be talking at you, not talking with you, okay? Now, when the trial's over with, we're happy to talk. This is the last chance. Anyone want to say anything or have any questions for us right now? I look forward to working with 6 of you.
Okay, ladies and gentlemen, we're going, okay, ladies and gentlemen, we're going to ask that you follow the bailiff into the hallway. We might call some of you back in to do some follow-up questions. So just go have a seat in the hallway. Follow. Yes, hold on a minute.